to you as a link, as well as the slides that Chris will be sharing with us post-event. Again, so glad you can join us. I see a lot of familiar names from my time working at the Indiana Commission for Higher Ed, so glad you all are here. Professional licensure can be a very difficult ocean to navigate. And I'm very happy to say that we have folks here to help us. We have HELP, the Higher Education Licensure Pros. They've been helping us for the last 2 years and have done a number of webinars for us. So I'm going to turn it over to Chris Mull from HELP to do some introductions and get us started. Thank you, Chris.
Yeah, thank you so much, Sarah. And thank you all for making time on your Thursday afternoon to participate in this. We do have 90 minutes scheduled for today. I hope you're able to stick around that whole time. We'll be doing a lot of different things and digging into this professional licensure regulations. So if you don't know me, as Sarah said, my name is Chris Mull, and I'm half of the team here at Higher Education Licensure Pros. Nan was going to join us this afternoon, but unfortunately she had an unexpected family situation come up that she needed to take care of. So you'll just be hearing me today, for better or worse. But I've been doing this work for a long time. So I started out working for Capella University, which is a large online institution headquartered in Minnesota. For over a decade, I worked in their legal department. I got to create and lead a small team of professionals that were solely focused on this. So we spent our whole time researching educational requirements for licensure in other states and territories, making sure that our curriculum was aligned appropriately, and if it wasn't, making sure that we were providing that information to students. Of course, building out these compliance processes in relation to the current July 1, 2020 disclosure requirements was a big part of that. So I've been doing this for quite a while, but I've been most excited about our work the past few years. So Higher Education Licensure Pros was created to support institutions of all types and sizes with this work in reaction to the July 1, 2020 disclosure regulation. And now here we are today, right? We've got some big changes coming for this July related to this work. And that's what we're going to be focusing on. So here's our agenda for this afternoon. First, I'm going to do an overview of what the requirements are, again, with this particular focus on the changes coming for this July 1st. There are some connections with SARA policy, and I'll point those out when we get there. We have plenty of time for your questions today, so I'm hoping that you do have questions. About 20-25 minutes from now, we'll have specific question designated time, and Sarah's going to help field the questions that come into the chat. So if you do have questions while I'm talking, feel free to put those in the chat. Again, I'll try to address those the best of my ability when we get to the question portion. You can also come on camera or audio and ask your questions live when we get to that part too. And then the last about 30 minutes that we have together today, really hoping to have a discussion. So would be looking for you to share kind of how you're implementing these changes or these requirements at your institution, or how you're planning to do it. If you're not quite there yet, that's totally fine. But I think sharing information definitely is helpful for yourself and your colleagues here on the line today. And it's been really great. So as Sarah mentioned, we've been doing these sessions for the other states in the MHEC region the past few weeks. And I think there's been some really great collaboration happening between institutions. So hopefully we can have that here today together too for Indiana. Wanted to point out that I am an attorney and we are talking about regulations today, but this is not legal advice. So there are many components of this work that do require legal counsel. I'll probably point out a couple of those along the way here today that are particularly tricky and would require some analysis of risks and weighing in from your own legal counsel. So do seek that out. I just wanted to make that clear, not legal advice. Don't take it as such, what I'm going to be sharing with you today. So, thank you. And with that, I will get started. So again, I'm going to provide an overview here of what the federal Title IV regulations require related to professional and occupational licensure, in particular around some new responsibilities coming online for July 1st. So on the next few slides, I'm not going to have the exact language from the regulations. That's on purpose. This is often confusing language that isn't clear on exactly what the department's looking for. So I've used that along with the commentary the department provides and information that U.S. Department of Ed staff have been sharing through email with myself and others, and kind of compiled it into the next few slides. But when you get the slide deck, I do have at the end some appendix slides that include all of this exact language from the regulations, as well as links, of course, to where you can find that in the code or Federal Register. So what is this, right? What are we talking about? When I talk about this work, I really like to break it down into 3 responsibilities that all institutions have if you're participating in the Title IV program, so federal financial aid for your students. First responsibility, institutions need to understand how your programs meet educational requirements in states and territories. I'm going to get into each of these here in the next few slides. But that's it at a high level. You have to have that understanding of how your programs meet educational requirements. The second responsibility, and this is the new one that's coming online for this July 1st, institutions must be able to certify that your programs meet the educational requirements wherever you're enrolling students from, along with where you're recruiting and advertising for that specific licensure program. And then the third responsibility is around communicating. And this isn't new. This is really continuing with the existing requirements and responsibilities that the department put in place July 1st of 2020. So you still have an obligation to provide disclosures, both public disclosures and individual direct disclosures related to your licensure programs to particular audiences at specific times. Again, I'll get into these details here as we go. So a little more on this first responsibility, understanding. So institutions, again, you need to understand how your licensure programs meet the educational requirements in each state and U.S. territory where you're recruiting for that program or advertising it, and in particular where you're enrolling students for that licensure program. So I wanted to pause first because there's actually a lot that we can unpack in this first sentence here on the slide. What's a licensure program? What does that even mean? Well, unfortunately, we don't have a list provided by the U.S. Department of Education or really anyone else that gives you exactly what your list should be of licensure programs. So it is up to each institution to determine which of your programs are in fact licensure programs or not. We do have some guardrails or loose guidance, at least, from Department of Ed on this, when things that you should consider as you're evaluating your program. So the first point is it designed to lead to some sort of professional or occupational license? Second point, is it being advertised as doing that? So if the program's been designed to lead to a license, or you're advertising or marketing it to lead to a license or to some profession or occupation that requires a license, then it probably needs to be on your list of licensure programs. I should also point out and pause here and say, what does licensure even mean? I know there's often some confusion around this on kind of where the boundaries are. But for these purposes, licensure is really a state or territory government issued credential, whatever that's called, that's required in order to work in a particular profession or occupation in that state or territory. So we're talking about things, again, that are required by a state licensing board, for example, or agency or other state entity in order for someone to actually work in that field, in that profession or occupation in that state. And because states get to set which professions or occupations they regulate, right? This is a state level issue. We have different terminology around all of this. So it might not be called a license or licensure. It could be called something else like certification, endorsement, authorization, registration. The list goes on. Whatever it's called, if it's a state issued thing that's required, that's what we're talking about. That's licensure for these purposes. Not a private issue, or private organization issued credential, only those that are issued by the state or territory government. So I'm going to keep saying license and licensure throughout the day, but keep in the back of your mind that it could be called something else, but it would still fall under these regulations if it's required for employment. All right. Sarah, I see you have a hand up. Go ahead.
Yeah, we have a question related to physical location. Can you please explain exactly how a location policy might help avoid the issue of a student enrolled in a face-to-face program who takes an online course during their first term? Can a location policy avoid the student being treated as a distance student?
That is an excellent question. I'm going to put a pin in that for just a moment. 'Cause when we get to the next slide, I'm going to talk about student location, but I'll keep that one in mind, make sure that I'll address that. Okay, so let me finish this one out with the understanding and responsibility. Again, this is your first responsibility that all institutions have. It does apply to all of your programs, all modes of delivery. So the question that was just asked was, in reference to distance education. There is a connection to that in the new certify responsibility, which I'll get to in a moment. But really, these regulations apply equally to all of your licensure programs, no matter how you're delivering them. So that's important to keep in mind. And then the last thing I'll point out on this slide is some of you have been doing this work for a while, are familiar with kind of this third understanding, or I should say a lack of understanding, right? That you haven't determined yet if your programs meet the educational requirements somewhere, or you haven't made an attempt even to determine yet if it meets or not. Under the current Title IV regulations for disclosure, there is this third category of not determined or no determination made. That's not only an option, but something that institutions have to disclose in your public disclosures currently if you have any locations where you haven't determined. So moving forward for this July and after, you still might have some scenarios where you've not determined for a particular state or territory for some of your programs. That could be the case for a while. It's going to depend, again, on the particulars of that situation for that program and for your students, and most importantly, where you're enrolling people from and where you're recruiting and advertising for that program. But pointing that out just because it lives, right? It's here with us today, and will continue maybe in a slightly different fashion after this July 1st. All right, so I'm going to shift gears now to that second responsibility, and I'll get to that question that you had asked, Sarah. So the second responsibility is certify. And this is the new one, brand new for July 1st of this year. It's related to the program participation agreement. And the PPA is essentially that master contract that every institution needs to sign with the US Department of Education in order to participate in the Title IV federal financial aid program. The PPA has been around for a long time. It's not new. What is new is that the Department of Education has added a new section that requires institutions to certify that your programs that are licensure programs do meet the educational requirements where the institution is located and where your students are located at the time of initial enrollment into that licensure program. Now, there is an exception to that second bullet point here that the department's provided, and it's shorthand, it's being called the written attestation. So the department has created this exception. You can still enroll someone even if they're located and it does not meet state or territory or one where you haven't determined, as long as you have a process in place and ultimately secure a written document from that student where they attest that they're going to seek licensure and employment in a particular meets state or territory after they graduate. We're going to get into some more details around this when we get to questions, I'm sure, but also discussion. But those are kind of the basics of the written attestation. It's meant to be an exception to this enrollment restriction, and it does need to be more than just a short kind of checkbox. It's got to have a little meat behind the process itself of how you're educating and informing students. And then ultimately, they're going to provide you with some sort of written documentation that they plan to seek a license and employment in a state where your program does meet the educational requirements. So let's talk about student location, and then I'll get to that question. So where this one, again, is connected to where your students are located at the time of initial enrollment. So some people, if they haven't been in this world very long, are kind of like, well, isn't it obvious where students are located? It's actually not. There can be lots of different ways when an institution determines where your students are located And sometimes you're going to have different determinations for different purposes, even, especially moving forward after this July 1. So what is required is that each institution has a formal student location policy in place that is used for these purposes, for both certifying under this new PPA responsibility and for the direct disclosures that, again, currently exist but will continue after this July. So that student location policy, again, it does need to be a formal institution policy. It needs to go under the same kind of review and updating processes that any policy would. And you do need to make that available to the Department of Education should they ask you for it. Another thing that we know about student location policy from Department of Ed is, it should be applied consistently across the institution is the language that they've used. However, there does seem to be options for treating different populations of students or different scenarios a little bit differently under the policy. The Department of Ed talks about this in the commentary that they released with the final regulations in October. So the question, if I can remember it exactly, was asking about, can we set up our student location policy so that we're treating students who will be coming to our Indiana campus to do a face-to-face program? Can we treat them as if they're located in Indiana at the time of initial enrollment? And then the question is around the distance education piece. So there is language in the regulation itself around this new responsibility that it says you need to be able to certify that your program meets where the institution is located and where your distance education students are located at the time of initial enrollment. The reason why I don't usually lead with the distance education piece is because it's very confusing. So Department of Ed is decided to utilize a definition of distance education from the May 2023 Dear Colleague letter that they put out, which really focuses more on accreditors and their relation to distance education. But nonetheless, that's the definition they're applying. And what that definition says is that if a student is taking one or more class online, then they're considered a distance education student. So on top of that, some further clarification from Department of Ed staff recently, they're indicating that if you have a student who's going to be enrolling in one of these licensure programs, if they will be or even could be taking one or more class online during that first term of enrollment, then they're considered a distance education student for these purposes. Okay, so how do we fit all of this together? Well, that's why I'm really focusing on students in the broad sense rather than distance education students as a narrower population. So if you have a student location policy in place that's clearly spelling out where students or prospective students are located at that time of initial enrollment, that's really the controlling factor because, again, you have the ability to set your student location policy as long as it's reasonable, right? Reasonable and defensible. But you set that policy and then you're going to apply it consistently as we go forward here after July 1. So I do think it's possible that an institution could choose to have their location policy indicate that if someone is, physically moving to your campus in Indiana, they'll be residing there, they're living there, that's where they're doing their learning. Even if they end up taking a class online, they're going to be doing it from Indiana, right? So again, the presumption is they're relocating to your campus for the program. So it would seem reasonable to me that you could use your location policy to treat them as if they're located in Indiana. Of course, different minds have different interpretations of this. Student location policy is an area where I recommend you seek out your legal counsel, make sure they understand, what the purposes of it are and how it's going to be applied to different populations of students and ultimately what the results of that application are going to be. Sarah, go ahead.
Yeah, we have a couple questions. So follow up to the first one regarding face-to-face and then a student taking a course online during their first term. The question proposer says, so we are only interested in state-issued credentials, not professional organizations that offer certification.
Correct. So the Title IV requirements are really about state issued, state required. Now it gets a little tricky because for some of these state issued or required licenses, there will be a tie-in with a private certification. So as an example, to become a dietitian, you have to first earn that private certification through the Dietetic Association. Forgive me, I'm not remembering the exact name off the top of my head. But that's one of the basic requirements to qualify for a license as a dietitian in states. So there could be a connection with one of these private issued, but really, if you don't have to disclose all or any of the potential private issued credentials that are out there, it would only be relevant if it's a requirement for a state issued license.
Thank you, Chris. And we've got two more here. One is about student location. For the student location, is this and or, meaning you need to report location at the time of initial enrollment and or where they attest to plan to be employed? And then a question after that for distance education, does this mean 100% online or any portion of the course is online?
Right. So the first piece, the first question, I did want to clarify because I know this can be confusing too, but there's not actually a report or reporting requirement per each individual student that you're going to be sending to the Department of Education. How the PPA certification process works is every institution is on a cycle of when they have to renew their PPA certification. And my understanding is that can be anywhere from 1 year up to like 7 years time. And that depends on a number of factors. So whatever your institution's renewal cycle is for your PPA certification, and I would suggest you contact your financial aid team because someone there is responsible for this, I'm sure, and very much on top of that. But that's technically when that certifying happens, is as part of that regular normal PPA certification process. But the expectation is that all institutions would be able to certify starting this July 1st. So it's a little bit weird because you maybe not actually sending anything to the Department of Ed even this year, right? Depending on what your PPA cycle is. But the expectation is the department's adding this. And so every institution that participates in the PPA, this is what you're required to do starting this July 1st, even if you don't actually recertify through the PPA for a while. Hopefully that makes sense for that piece. And then the kind of second part of that question is it's where the student or applicant, maybe a better way to think about it, applicant or prospective student, where they're located at the time of initial enrollment in the licensure program. So that's the key, that you're certifying that you meet the educational requirements where that prospective student or applicant is. If you can't certify that for a student, right? So they're located in a does not meet or not determined, there's this exception, the written attestation that the Department of Ed's created, that you can still enroll that individual student or prospective student into that program as long as they go through your written attestation process, and you have that documented written attestation from them in their record, which you would need to be able to produce to the Department of Ed should they ever ask you for it. So again, it's meant to be an exception, but generally institutions should only be enrolling students in locations where your programs meet the educational requirements.
And Chris, the last question, and we'll let you move it forward. And it must be a formal university location policy and not guidance or an institution statement, say, used by the institutional reporting team.
Right. So my understanding is the department expects it to be a formal policy, not just guidance or process documentation. So something would need to live in your formal policy. Obviously, you could have additional information and components and things that are considered as part of separate guidance document internally or processes and that type of thing. But you need to have some sort of formal location policy in place.
And Chris, we have Carrie Valansky, who has her hand up.
Go ahead, Carrie.
Hi, Chris. Carrie Valansky from Hanover College. Just circling back on the student location, Can you speak a little bit more about where they attest to plan to be licensed and employed after completing the program? So that was my and or piece. So do you also have to collect that, or is that just an option?
It's not an and, it's an option for that exception. So if you have the scenario where you can't meet this certification requirement for that student because they're located somewhere where your program does not meet or you've not determined, the department's created this exception. So it's not, you don't have to get a written attestation from all of your students. It would only be those that you're enrolling to the program that are located in a does not meet or not determined state or territory.
Thank you.
Yeah, you're welcome. Great. Thank you for all for the questions, and keep them coming. We'll keep addressing them as we go here. I did want to point out before I move on to the third responsibility, this concept of time of initial enrollment. So this is something where the Department of Education has not provided a particular definition or exact point in time. So this is another area where it is important that your institution evaluates and understands what you're going to use as your initial time of enrollment in these licensure programs. This can become particularly important when you start thinking through the scenarios of, what if we have undergraduate students who are coming in as kind of like pre-declared as a major, let's say a nursing major, but they don't actually formally get admitted to your nursing program until later on, right? Maybe their second year, third year, because they have certain prerequisites and things that they have to meet, a GPA threshold, whatever that is. So it's important to think about when you're going to consider those students as initially enrolled in the program. And we can, again, get into more specifics around there, but I did want to point that out. The only kind of framework or guidance we have from the Department of Ed around this is, it should be a point in time before substantial financial commitment to the institution. So your initial enrollment, institutions are setting them at different points in time. Some are pretty close to the first day of classes for that first term. Others are way back, at the start of the application process. I know some institutions are setting it at the time of admission to the program, and there's lots of things in between there. So this will be another one. Again, I may want to weigh in with your own legal counsel on it, because depending on where you set that time of initial enrollment, it's going to have a trickle down impact and open up some risks, for different areas. All right, so I'm going to keep moving here. This third responsibility is around communicating. And as I said before, this is not new. This has been around since July 1 of 2020. And Department of Ed has made some small changes here, but really it's the same responsibility that you all have had for the past few years. So we have both public disclosures and individual direct disclosures that are required. For the public disclosures, here's where the change comes in. So under 2020 version, Department of Ed regulation says institutions must list on your website those states and territories where you meet and do not meet education requirements, and those where you've not determined or you have no determination's been made. So there's those three kind of categories, three buckets, if you will, that should be on your public disclosures now. And I know, working with institutions, again, from all over the country, different types and sizes, a lot of institutions still, they have quite a few states and territories listed as not determined on their public disclosures. Again, under Title IV regulation, that is perfectly acceptable to be in that situation today, to have a lot of states and territories where you haven't investigated if your programs meet or not. Under the new July 1, 2024 changes, Department of Ed has removed that third category. So you're no longer obligated to disclose those states and territories where you've not determined or haven't made a determination yet. What you are obligated to do is have a listing of those states and territories where you've determined your programs meet the education requirements and those where it does not meet. So that's the public disclosure piece. Some of my commentary around this here is, there probably are going to be scenarios for some of you, for some of your programs, where you'll not have all 59 US states and territories listed anymore on your public disclosures. So again, the 2020 version, that expectation, that obligation is you're going to list something for all 59, whether it's in a meets or it does not meet or are not determined. Moving forward, you don't have to list those not determined. So there could be scenarios where institutions have less than 59 states in your public disclosures. Caution around this though, if you're recruiting or advertising for that specific licensure program in a state or territory, the Department of Education staff have indicated their expectation is you know that the program meets the educational requirements in that state or territory if you're advertising or recruiting for that particular program there. So I just point that out because you may have some of these states and territories that are on your not determined list right now, but if you're going to do specific advertising or recruiting in any of those, you would need to be able to move them to the meets portion of your disclosures and know that your program's meets there. All right, so I want to mention that I'd point out a connection to SARA policy. Well, here it is. So SARA policy 5.2 has been in effect for several years. It's really connected to the July 1, 2020 version, these disclosure regulations. It does do a couple of things in addition to or different than the federal regulation. So SARA policy says if you're disclosing that you've not determined that your program meets, first, you should be making all reasonable efforts to make some sort of determination, whether it meets or doesn't. And if you still can't, then if you're disclosing not determined, you should be providing the board contact information for every state and territory licensing board or agency. So noting that, in case you will continue to have some of these not determined disclosed, we have this SARA policy that's in effect. I do know that there are some proposals moving forward with the SARA policy modification process that is currently underway. So it's possible that this one could be changing in some fashion in the future, but that process will not be complete until after July 1. So we will have a period of time where the current SARA policy is in effect along with these Title IV changes for July 1. All right, I'm going to wrap this one up then. So individual direct disclosures, again, not new. Department of Education actually did not change anything at all with this section of the regulation. So we have the exact same regulation language that we have with the 2020 version, which interestingly enough is creating a little bit of a mismatch here on what's going on. So these are still connected to student location. And as I said before, every institution should have a student location policy in place that you're applying for these purposes. If you have a student who's located in a not determined or it does not meet state or territory, you need to be sending them a direct disclosure that lets them know that before they enroll in your program. Kind of my own side note here, moving forward after this July 1st, those same students would need to have a written attestation on record in order for you to enroll them in your program, right? So going back to that certify responsibility, this July 1 and after, you can only enroll students if they're located in a meets state or territory, or if you have that written attestation process completed and have a written attestation on file for them in the record. And then finally, current students, again, stays the same here. You have 14 calendar days to provide them with direct disclosure. If something changes in a state or territory and your program no longer meets the requirements, if something changes about your program's curriculum and for some reason you no longer meet it, or if that student changes locations and lets you know that. So you have some different ways, but any way that a student gets into a does not meet scenario, you have 14 calendar days once you become aware of that change to provide that direct disclosure. And I'm going to pause there. I know, Sarah, you had your hand up, so go ahead if you'd like.
Yeah, we have some really good questions in the chat. First one is, we have 125 credit hour accounting program. We publicly disclose that in order to sit for the CPA exam, a student should get a double major or do additional graduate MBA work to get to the 150 credits. Do the new regulations mandate us to not enroll any students in our current program without the declared second major or without declaring the additional work in the MBA program?
Yeah, this is a great question. So I think accounting and engineering are kind of the thorns in people's sides at the moment around this work. What do we do with these programs? So I think for accounting in particular, especially undergraduate accounting, right, there are very few undergraduate programs around the country that are 150 semester credits. Most are less than that. And you're correct, person who asked the question. 150 semester credits is the magic number for licensure for accountants. So to become a CPA in any US state and territory, you have to be able to document that you've completed 150 semester credits of particular coursework, depending on what that state's looking for with accounting credits versus business credits and other specifics there. So the reality is that an undergraduate program in accounting is probably not designed for licensure anymore, right? If it's not 150 semester credits and it takes at least 150 semester credits in all states and territories, it seems like that curriculum would really not be designed for licensure anymore. It's designed to maybe help someone start down that pathway, right? To get them on that road, to get them on the track. But they're going to need to do more than just that program to qualify. And then kind of the second consideration, as I mentioned before, when we're figuring out what's a licensure program, right? You think about what it's designed to do and what it's advertised or being advertised to do. So as long as you're not advertising your undergraduate program as helping qualifying someone for a CPA or leading directly to a CPA, if you can put some language that makes it very clear what the limitations are around the program and licensure and how it's just the first piece of a lengthier pathway, that would seem to help alleviate any kind of confusion with the advertising component too. So I know that many institutions are taking a look at what they're saying about these undergraduate programs in accounting through the catalog and course descriptions on their websites and any marketing materials. I think that's a really good approach to that. Make sure that it's clear it's not a licensure program by itself.
And Chris, just two more. And I think I can answer the third one, but I thought the new PPA 2024 regulations applied only to distance education programs. And this is one of my favorite ones because it talks about advertising. How do online and social media advertisement recruitment strategies figure into expectations around public disclosures? And I'm quizzing myself here on this one. Can you clarify, is the deadline to have the policy and communication in place but by July 1st or May 1st? And my answer to that one is everything has to be ready to roll out and active July 1st.
Yes, you're correct, Sarah. July
Woohoo!
1st is the key date, right?
Great.
And yeah, and then even with July 1st, we get a little more complicated because you need to also consider what is your point in time of initial enrollment at your institution. So I mentioned before, there's kind of a spectrum of time there. So you do need to think carefully about, okay, when do we consider these applicants or students to be initially enrolled? If it's this July 1st or after, then the new PPA certification responsibility kicks in for all of those students. And again, you have the continued disclosure responsibilities. There have not been a whole lot of changes here, no changes at all with the direct disclosures. So I'm going to go back to some of those other questions here, Sarah. I think the first one was around the person thought that this only applies to distance education. I think, is that right? Yep. Oh, here, I found it in the chat. Okay. So, hi, Alona. So the PPA certification responsibility, the regulation language does include that distance education phrase, as I mentioned. So the challenge is the definition that Department of Ed is applying to distance education. I think in reality, it's a lot more broad than your distance education programs, right? So if you have potentially students who will be taking one or more class online during that first term of enrollment, no matter what type of class it is, gen ed or otherwise, the department's saying that they're considering them to be distance education students for these purposes. So that's why when I talk about it, I'm just saying students more broadly because if you're covering your bases for where any of your students are located, then you certainly will be capturing, where your distance education students are located. And as somebody else pointed out before, right, if you have a on-campus face-to-face program, even if it includes the option maybe for students to be taking a class online during that first term, but if you've set your student location policy up so that you're considering any student who's relocating to your campus to do that face-to-face campus-based program as located in Indiana at the time of initial enrollment, then that would seem to satisfy the requirements here, because you have to certify that your programs meet the requirements in Indiana anyway. That's the first part, right? You certify that the programs meet educational requirements where the institution is located. And then that second piece is where your students are located, or distance education students. But again, that's potentially a broader definition. So I'd say for any of you that are on a state border where you have commuter students, that's kind of the more tricky area here when we throw in this distance education piece, thinking about where those students are physically going to be located when they're completing classes. That's something to consider as you're finalizing or revising your student location policy and how that's going to play out. All right, I'm going to try to hit these, and then I'm going to flip slides, and we're going to officially start questions. But I'm glad we're getting so many questions already. Online and social media advertising recruiting fit into public disclosures, right? So thanks for this question, Katie. This notion of institutions should only be advertising and recruiting where your program meets educational requirements. That's coming from Department of Ed staff. So we don't have anything in the regulation itself, or really even in the commentary that they released. I am hoping that we're going to get some sort of written guidance from Department of Ed staff. It's anticipated that they'll be releasing some sort of question and answer document sometime soon. So I know I've seen other names here on this Zoom today, but there was a conference a couple weeks ago, the NASAPS conference in South Carolina, and there was a staff person from Department of Ed there, and he referenced that they were planning to release this kind of guidance, this document soon. So we're hoping that it is going to be soon. And I think it may illuminate a little further what the department's expectations or understandings are around limits to advertising and recruiting. But I would say for now, if you have targeted advertising that's being directed at certain states, whether that's through social media channels or search engines or aggregator websites, or whatever it is, it would be wise to get your arms around what all that is and where is being targeted, in case you do need to move forward with restricting some of those activities in some of those states. All right, so let me touch on this before we get to more questions, because it is important. Some of you may have heard the Department of Education released an electronic announcement a couple weeks ago. It was actually the same day that we were all at that NASAPS conference, those of us who were there. So they released this electronic announcement that's kind of opening a crack for some institutions to not be fully compliant with the new PPA certification responsibility by July 1st. So I want to first stress that this is not a blanket delay of the effective date. These regulations are still effective July 1 of this year, all of them. And this electronic announcement only applies to the new PPA certification section, so that new certify responsibility. It does not apply to the public or direct disclosures. So that communicating responsibility would still need to fully be in place by this July 1. This wouldn't help you, this electronic announcement. So what the crack here is, or what the potential opportunity is, if you have some sort of circumstances that your institution's in that are truly outside of the control of your institution, and that are pretty unique and time specific, the department's saying that institutions should document all of those things thoroughly. And then if there's an enforcement action brought by the department between July 1 and January 1 of 2025, you could use that documentation to potentially be successful in a defense to any enforcement action. So there's a lot of ifs and potentials in there. That's because these types of things are truly only determined on a case-by-case basis. Department of Ed staff reiterated that to me when I inquired a little bit about the opportunity here or what the limits are, that it would be decided at the time of the enforcement action on what is a sufficient defense here or what is not. So again, this is an area you'll want to consult with your own legal counsel on. If you think your institution could be in these kind of unique circumstances where you have things that are truly outside of your control, that are pretty unique to your institution, then it could be something to help you out here. But definitely seek counsel. Don't take this as a blanket, opportunity to delay your compliance efforts. Kelly, go ahead.
Hi, Chris. I'm sorry for this question. I think that you were talking to me, but I'd like to revisit the date of enrollment. Up until now, institutions have been given the autonomy to define their date of enrollment as long as they remain consistent. We have defined ours as the date that the student signs the enrollment agreement because they are signing a contract on that day. However, on a previous webinar and also Ed, they have recently said that the date of enrollment is the first day of instruction. This is problematic for some of our students who have signed an enrollment agreement for the May term and then for whatever reason have deferred their enrollment until our August term. These students would now be subject to the 7-1 regs. So it really boils down to if the student begins in May, they can take the program. However, if they defer to August, then they cannot. So I'm wondering how to proceed with these deferments. And there's more than one or two. As you know, we target returning students, our base, I guess our demographic is working adults. So it's not uncommon for them to say, hey, something came up in my job. I need to defer my enrollment. So what do we do?
Yeah, wow, yeah, that's a tough situation, Kelly. I would be curious on, so you mentioned another webinar and from the department, but that is different than my understanding. So based on the regulations that are coming out this July, as well as the current disclosure requirements as they exist, there was that flexibility provided for setting that initial enrollment, whatever that point in time is. But it sounds like you've received some information from other sources that there's really not flexibility. It needs to be connected to the first day of class for that first term.
Yeah, I asked the question on, I think it was the WCET webinar. I asked it in 2 different ways and I got the same answer, but that didn't make sense to me. And I checked with about a dozen other people who do what I do, and we were all under the same impression that as long as we were consistent, institutions could define that. So I wanted your take.
Yeah, I mean, I'm more kind of aligned with what your understanding was and what those others folks' understanding was. So as long as you have defined what your initial enrollment point in time is, and then apply that to all of your students. So it is going to make a big difference, right? For some institutions, if you set that at a certain point in time, you could have a lot of people who are subject to these July 1 changes that may otherwise not be. So yeah, I guess I don't know what else to say about that. That I haven't heard anything myself from the department or elsewhere that makes my understanding change that it has to be connected to that first day of class of the term. But that's obviously a very important thing. So that's something I'm going to add to my list to ask Department of Ed staff. I don't think I've mentioned this yet either, but I've referenced it a couple times, right? So Department of Education have provided a staff contact person that you can send questions to. I'm pretty sure that's how they're compiling this guidance document that they're anticipating to release soon. And you can continue to send them questions. They've said, like, we're not going to cut off questions when we release this guidance document. We're going to continue to take them. So that is a really important one to have a clear understanding around. If it has to be the first day of classes, then, you know, a lot of institutions are going to have a wider range of students who would need to fit under these July 1 changes, in particular, that PPA certification requirement. So Vanessa Gomez is the staff person's name with Department of Ed. And I can try to pop her name here in the chat if you're not familiar, but you can email her questions, and typically there's been a response within a few weeks.
It's already in there, Chris.
Did.
Thanks, Sarah.
Thank you. And Chris, I did email her, and she referenced the CFR where they mention it, but they also reference correspondence education. And we're not correspondence education, we're distance ed. So her answer didn't really apply to us. I just wanted a yes or no. So hopefully this will be addressed on the FAQ, but thank you.
Mm-hmm. Yeah, and sorry, Kelly. Again, I know I can understand the importance of this and why it makes a big difference. All right, so we do have time allotted for other questions. I was going to take a peek here in the chat. Sarah, if you had any that you had seen in the chat you think I should address right away, let me know.
Sure. One of the things I know that Chris, we talk about in these discussions are solutions, right? Iona has that they are using a Tableau program. Let me scroll down here. There we go. They're using a public disclosure Tableau map that includes online and on-campus programs with not determined as a status in some cases. But she does ask, how would this be represented under 2024 regulations? And a comment from Joshua was like, I'd love to see this in action if you could share the site. He said that's a really clever way to solve it. So again, her question is, as status in some cases, how would this be represented under 2024 regulations?
Yeah, so again, under public disclosures starting this July 1st, there's not an obligation to disclose publicly those not determined, but you can still choose to do it. So it sounds like, Ilona, you've set up, you know, a pretty robust visual way for the public or prospective students to click on a map and see what the status is. You could continue to have not determined listed for those states and territories where you haven't made a determination. That is perfectly acceptable under the regulation. So nothing has to change. If for some reason, if you don't want to disclose for some reason, you know, you could remove those. I understand that would probably make the functionality of the map not great. So.
Well, yeah, and still for the on-campus programs, I feel like we still need to have the not determined isn't, it's not an option for online, but it is still technically an option for on-campus. Mm-hmm. I think it would just be easier to keep it all in one place.
Sure.
Yeah, thank you.
Yeah, definitely a possibility.
And another good one, and I don't think we've had this question in some of the other conversations with the states, are these requirements still expected for licensure programs where students do not use financial aid?
Yeah, so this gets a little messy, but really if you can think about these requirements in relation to your Title IV eligible programs, it's not connected directly to an individual student's ability to access Title IV. So in order for the program itself to be Title IV eligible, you would need to be able to make that certification starting this July 1, that the program meets education requirements where all of the students are located, or you've had that, you know, written attestation exception secured from individual students. So hopefully that answers the question, but it's not, unfortunately, it's not connected directly to each individual's student's ability or desire to access Title IV. It's if you're offering the program as as a Title IV program, then you have to apply these requirements to all of the students enrolled in the program, even if they're not looking to access Title IV themselves.
And Chris, as a follow-up to Carrie's question, is there the same impact of programs that are quote unquote open enrollment, non-term based?
Ooh, that's a great question.
These folks have
So
some wonderful questions this afternoon.
yes, and I probably just don't know enough about the mechanics of financial aid and how that works. So I'm not going to be able to give you a concrete answer on this, but I'll just say generally that this does apply to any Title IV eligible program. So my assumption is yes, but exactly how that plays out if you don't have um, specific terms or how that lines up, I can't answer that piece of it. But my gut is telling me that these would still apply because again, it's any Title IV participating program is what we're talking about here.
And being a former English teacher and always wanting to know the definitions of things, we have a question to Chris. Why do you continue to reference distance education course during first semester? Why specify first semester?
Yeah, so this is coming from Department of Education staff. Their responses to my inquiries, along with other people I know, have been getting consistent responses through email from staff. Again, they're defining distance education in this new PPA certification section of the regulations to mean any student who's taking one or more class online during the first term of enrollment in the licensure program. So honestly, I don't think they got that first term of enrollment from anywhere else that's published at this point. I think they were just trying to put some kind of constraints around it. If they didn't do that, then we would have scenarios where a student starts a program that's, fully on your campus face to face with no online options during that first year or two, but then during the third year of the program they do have an option and maybe they decide to take an online. So it's a lot more messy. I think they were trying to just put a barrier around and define that as the first term of enrollment to give institutions something a little more concrete to work with.
And Chris, we talked about communication and how important it is. This comes from Heidi, and she says, how do you suggest we inform leaders of our institutions? Maybe through some website?
Yeah, so in the slide deck, when you have access to this, Heidi, we have included some additional resources which have links to recordings of different webinars. We also have a link there. If you're familiar with WCET's State Authorization Network, they have some good resources around this available on their website as well. So there are different ways you can get some resources together and share that with leadership. I will also plug MHEC is hosting a webinar next week that we will be presenting on the 30th of April. It's a 90-minute session, but we're really focusing the first 30 minutes on a leadership audience. So if you have leaders who would be able to attend, again, it's 30 minutes, so we know that their time is precious, but I'm going to try to really go over what these requirements are and impress upon them kind of the stakes here of why this is important, why institutions should be devoting resources to this work to make sure that you can be on track for compliance July 1 and after.
And then I love scenario questions. So we've got one from Carrie. If a student moves during matriculation in a professional program, is there a rule where the policy has 14 days to collect that information?
No, there's not, Carrie. So in your student location policy, you don't have to connect that to a 14-day mark. Where the 14 days come in for those direct disclosures is once you become aware of a change so that a student's located and it does not meet state or territory, then you have 14 calendar days from when you become aware. So would it be wise to put some sort of time frame into your policy that requires your students to let you know when they change locations? Yes, I think that's a great idea. You could make it 14 days, you could make it 10 days, you could make it 21 days. I don't know that the actual number of days necessarily matters, but having your students have an obligation to tell you when they move is an important component that I think most institutions would want to include in their student location policy.
And Chris, we are lucky that Carrie has her hand up, so she can maybe ask some follow-up questions or some clarifications.
Yeah, just a quick question, Chris. So if we have a student who lives in Indiana, they move to, let's say, Ohio, and Ohio does not meet the licensure requirements, that would be an example of when we would have to collect or notify the student, hey, you moved, heads up, you may not meet the licensure requirements for the state of Ohio.
Correct.
Okay.
Yep. And just to make sure people understand, you would not need to get a written attestation from that current student. So the written attestation is only at that initial point of enrollment in that licensure program. But you do have the responsibility to disclose through that direct disclosure to them.
And Chris, we've got one more. So we've talked about, programs and Title IV financial aid eligibility, but Tom asks, what if you're not a Title school?
Yeah, if you're not a Title IV school, these don't apply to you. So this truly is through the Title IV regulations. That's where these live. I'll say one caveat here is SARA policy 5.2 does extend these federal Title IV requirements to non-Title IV institutions that are participating in SARA. So if you're a non-Title IV school, but you're participating in SARA, then you would still need to comply with these, at least under current SARA policy 5.2. Again, that policy may be undergoing revisions, but as it exists today and will exist after July 1, you would need to comply for the SARA policy reasons.
And I believe, Chris, we are caught up, unless I've missed someone, but I'll turn it back over to you.
Great. All right, so what I'm gonna go ahead and do then is, hopefully, here we go. Well, before we jump into discussion, so we're moving on to this last phase of our time together today. I did have a poll question. So if you'd be so willing to take this poll, you can scan the QR code that's on your screen there. It'll take you right to the poll where you can complete it, or you can use your laptop or computer and go to slido.com and put in number 2561206. Either way, we'll get you to the poll and the questions. But what we're asking is, what is your biggest challenge with implementing these regulations, in particular, these July changes coming up? And then in just a moment, I'll present the link here so that you can see everyone's responses as they're coming in real time. All right, so here we go. Again, you can still take this. You can scan the QR code here or go to slido.com and put in the numbers. But let's see how the responses are coming in so far. Greatest challenge at this point is researching the educational requirements in other states and territories. That is definitely a challenge. You know, it's very time-consuming work. There really aren't a whole lot of shortcuts available. And because states do get to set their own requirements, you know, they can be different, which is why it's so important to actually dig in and research what's going on in those other states and territories. Some of you have limited support from your leadership. Sorry to hear that. I know that's not great. It's really hard to wrangle the people power you need and the resources you need to get this work on track if you don't have the support from leadership. Some of you haven't started yet. That's all right too. Thank you for being here today. Hopefully you'll walk away with some new information and ideas for getting started. And then defining student location and initial enrollment, as I've mentioned a few times, those are really important. And it does seem to have some level of flexibility with those things. So important to have your definitions in line and those policies created. All right. Well, I'm going to move off of this then and move us to discussion time. So, as I mentioned before, would love it if you're willing to share how you're doing things for your institution, or even just what you're thinking about doing. I think this can be really beneficial to others as well. So, the first one I wanted to talk about was the research and program or curriculum comparison. Um, I think we're 10 for 10 on the biggest challenge being research for people. So, anyone want to share how you're tackling that at your institution? What kind of processes or systems you put into place? Who's doing the research? I will say too, I know we have some members of the Bookmark, which is Higher Education Licensure Pros online database of educational requirements. So not meant to be a commercial or a plug for us today, but I know some of you are utilizing the Bookmark in your own processes and efforts for this work. So hopefully that's a useful tool if you are using it. Anybody willing to share? The curriculum comparison piece too can be very time consuming, and you would need to have somebody who knows the curriculum. So, getting faculty members involved or program directors, getting their attention and time, I know can also be a challenge.
Can you hear me? This is Gwen in Fort Wayne, Indiana, with the University of St. Francis. We've done a lot of partner work, me being the institutional research director, and then the person who's the director of assessment. And then we reach out to the program director and work together with them. A lot of them from their program level accreditor have a lot of resources already that they've been supplied by that program level accreditor that give us a good starting place. But it's definitely a partnership between us and the curricular expert.
Thanks, Gwen. And that is a good note, right? If you have, oftentimes these licensure programs will have some sort of specialized accreditation or programmatic accreditation that they hold. So great idea to see, what information and available resources there might be through that accreditation process or through that programmatic accreditor itself. Anyone else willing to share how you're tackling the research or curriculum comparison work? I won't call on people, so don't get nervous about that. But if anyone does have anything to add, again, it can be really useful. If you want to talk along those lines around documenting, so I think I mentioned it at least once, but the importance of documenting your institution's decisions, even around these things, like your definitions and processes, but also it's really important to document when you're making these meets determinations, right? So what information is being used to make that determination, who's making it, what did they base that on? So to have all of that documented and then retained and made available in the future if needed, I think that's an important thing to think about too.
Chris, we have a question in the chat. Go ahead, hand is raised.
Hey, Chris, these regulations, as far as disclosing what programs meet and do not meet, they're not new. The only thing that's different is the cannot determine. So for a long time, we have had it disclosed on our website, the states that do and do not meet. I don't even think we have any to be determined. But we have, I mean, we're 100% distance education. So we have a state licensure and certification site that we refer students to, and that provides all of our links to licensing boards, states that we do and do not meet. And again, we've had that for a couple of years. But we are also one of your people that use the bookmark. Actually, just beginning this year, we will be using it for a couple additional programs that we'll need to make disclosures on. Our individual schools had done the research before, so I guess we're lucky that way that they had done that before we had the opportunity to use your services. It is a lot of work and it is time consuming, but once you do it, it's easier to kind of keep up with it.
Mm-hmm. Yeah, thanks, Kelly. And definitely, different institutions will be at different points with this work. And I think if you do have the majority or, quite a few online programs, you're probably a little bit ahead or a lot ahead of some of the other institutions where this hasn't been as much of a priority. If, you've just been disclosing not determined because all of your students are, located in Indiana. But that may need to change again, right? So we've got these new regulations coming online for July 1, and you have to really be able to assess where are your students coming from and where are you recruiting and advertising from, and make sure that you do have those meets comparisons for those locations.
Chris, we've got Tom with his hand up.
Great. Go ahead, Tom.
Yes, hi. Just to follow up to the comment there, we also have a map where we indicate directly where we are or are not approved. But my question was with the attestation statement, and any concerns anyone may have about having an attestation statement that you do not meet the requirements in that state for licensure that the student fills out. But that state Department of Education might actually be indicating to citizens in their states that somebody could enroll in this program and somehow seek licensure through reciprocity or transcript assessment.
Yeah, so if I'm tracking you, Tom, you're just like concerned about the connection between state authorization.
And I'm speaking to educational licensure right now, and specifically to the interstate reciprocity agreements for reciprocity with teacher licensure.
Sure. Okay, great. And we haven't touched on reciprocity or compacts, licensing compacts yet. So thanks for bringing this forward. So under these July 1 changes, when the Department of Education released the regulations, they provided a lot of commentary around it. And they did give one specific example related to teachers, where it is talking about institutions can use things like the NASDAQ, Interstate Reciprocity Agreement for Educators, as a point of information when you're making these meets determinations, right? So for educators, it is pretty unique. It's a interstate reciprocity agreement. It's not a licensing compact. Those are a little bit of a different animal, but the reciprocity agreement does allow for many instances educators to be licensed in another state simply based on the fact that they completed an Indiana approved educator preparation program. And then some states put extra requirements on there. Maybe they would have to go through the Indiana licensing process first and bring that Indiana teacher or educator license with them. And then there are some states that still retain some pretty particular requirements. So even though they participate in NASDAQ, they still expect all applicants to demonstrate through their transcript and other application materials that they've satisfied certain classes or certain student teaching hours or that type of thing. So the NASDAQ reciprocity agreement can be used as a basis for an institution to say that your program meets the education requirements. But I just want to caution here that it's not like a necessary blanket yes. So just because Indiana participates in the NASDAQ agreement and virtually all other states do, it wouldn't necessarily be an automatic meets. You would need to dig a little further and make sure that there are not specific educational requirements still that other state is going to require. Or if they do require an Indiana license, that's something that you would obviously want to disclose to your students so they knew that the process is, okay, I can get an Iowa license. I'm making this up. I don't know if it's true, but I can get an Iowa license if I first get my Indiana license, and then I take that to the Iowa Board of Educated Examiners, and they would say that satisfies. Hopefully that makes sense. And I know I hadn't talked about it yet. So it is a consideration, though, that you can factor in reciprocity agreements and licensing compacts when you're doing this research and making those determinations.
So would you be able to then say that your education program meets the educational component of licensure, subject to additional state required state requirements and or ancillary items like background check, et cetera?
Right. So we've got things that need to be part of your degree or educational program required for license. And then there are a lot of other things, right, that happen outside of a program that are required, such as background checks or even the licensing exams, maybe some specialized trainings that are unique to that state, or CPR training, something like that. Technically, you don't have an obligation to disclose those things happening outside of your program. Is it a good idea? I think it's a good idea, at least to generally give your prospective students an idea that these are the kinds of things you might have to do. But as far as making a meets determination for the certify responsibility, and then for the disclosures that are required, it is specific to what has to be part of that educational program. So Tom, if you have a NASDAQ participating state that will accept another state's approved educator preparation program, then as meeting educational requirements, then you can say, yes, we meet the educational requirements for that state.
Harry, your hand's up.
Yeah, this actually came into question today because we were looking at our nursing program, and nursing, is a little bit more complicated. They do a lot of compacts. So should this be on the table that we're all creating, where we have that column that says meets or does not meet? Could we do that it meets asterisk and have some type of statement that Alaska participates in the compact with the state of Indiana? So that's my first question. Second question would be then, if you can do that, do you just put that in the individual student letter?
So if you're using a compact to help you make a meets determination, basically what do you need to disclose or document around that?
Yes.
Yeah. So again, we kind of have here's the absolute floor of, something you have to do for minimal compliance. And then maybe what's a good idea to do for other reasons, including making it clear to students and the public. So I think with the floor itself, you wouldn't necessarily need to disclose how you meet it, right? That's not part of the disclosure requirements that the department's put into place. It really is just that expectation that you have a listing of meets or does not meet states and territories. And then if someone's located in a does not meet or not determined, that you send them that information prior to enrollment. So that's the floor. But I think it's definitely helpful to include some information about how you're meeting or why, or if there are special considerations like relying on a compact agreement. That's going to make it more clear to your prospective students on what's actually going to happen when I graduate. How do I actually get that Alaska license? And they're going to have to know, here's how the process works in Indiana, and then you can utilize that to practice or be licensed. I did want to caution here for nursing. So I think there's an unsettled question in my mind on how far the department is willing to extend this idea of compact agreements and reciprocity agreements. And there are some key differences in how compacts work versus this NASDAQ interstate reciprocity agreement for teachers. And they gave that specific example about teachers in the commentary. They didn't provide any other examples or comments for other professions. So just as a note, like for nursing, right? If a nurse is part of the compact state, so Indiana is part of that, and if someone applies for and earns an Indiana multi-state license, then they can practice in any other multi-state compact jurisdiction using that license, multi-state license that was issued by the Indiana board. That's not really the same as taking your Indiana license to Iowa to get an Iowa license, right? So that example I gave before for teachers, there's some differences there. And maybe the differences don't matter to the department. I don't know, but it's just a question that I have, which I've recently asked department staff about, and I haven't gotten a response yet. So I just wanted to say that because I would feel better having said it. But I do know that there are institutions that are already working through these compacts, including nursing, to sort through which states participate and which ones don't, and to use that in helping them really figure out what's going on if their programs meet or don't meet.
Thank you.
All right. I really enjoy these discussions, and also because it often brings up more questions, which is great. So I will bring us back to the discussion here, maybe to close us out. If anyone's willing to share anything about your student location policy, so if you've had one in place for a while, but you're working on revising that in light of these July 1 changes, if you have ways that you're setting that up so that you're treating your campus-based face-to-face students that are relocating to Indiana, just curious kind of what things you all have been working through or you're planning to do, if anybody's willing to share. All right. That's all right. Sometimes we don't have the ability or desire to share. So I think what I'll do is just kind of move us on then towards closing this out for today. I know we just have a few minutes left anyway. So I mentioned before, we do work with institutions. If you'd like more information, you can seek us out on our website. You'll have access to this deck later. You can find us online. But I had one other poll here. If you bear with me for a moment, I'm gonna have to change something here. You get to see the back end of what Slido looks like. Here we go. So if you would be so kind as to take this poll question. This one's going to show up as a word cloud. So if you want to put in a couple of words or a short phrase here on what your first order of business is going to be after today's session or tomorrow, whatever. Again, you can scan the QR code there and take the poll on your mobile device, or go to slido.com 2561206. And then I'll pull up the results here in just a minute as we start to close out. All right, so we've got some responses coming in. Please continue to do that. You can find the QR code on this screen now. We've got research as a big priority. It looks like several of you have put that one in. We've got some praying happening. I think that's always a good idea. So the last state we did this for, someone said have a margarita. Oh, there we go. Open a bottle of wine. So we've got prayers and some chemical libations to help smooth over some of the stress.
But nobody said run away, which is good. We're tough. We can do this. We got grit.
That's right. That's right. I was going to say we've got some other things too. Adding the territories, so those can be a challenge. There are 59 listed jurisdictions, so the 50 states plus number of territories, U.S. territories. Emailing leadership, talking to university administrators. So again, if you have the opportunity, if your leaders may be available even for 30 minutes or part of that on the 30th of April next week, encourage you to invite them to join our webinar next week. Great. All right, well, thank you all for participating in the polls today. Thank you for your great questions and discussion. Here's our contact information if you want to get in touch with us. Again, you can find us on our website, or you have my email, phone number, and LinkedIn there. So thank you all for coming today.
Thank you all so much. And as a reminder, this session has been recorded. And once I get the link prepared and the slides, I'll ask our communications director to post them on our website and make sure that you get that information. Thank you all so much for the wonderful questions. And thank you, Chris, for providing some guidance to us. We appreciate it. Have a wonderful day, everyone.
Take care. Bye.
Bye-bye.